We have Mr. Smith and Mr. Harris is somewhere. Okay, there's Mr. Harris. All right, Mr. Smith, which case are we calling first?
Miss Corley White.
Okay, Lene Crowley White. How are you, Mr. Harris?
Your Honor, I'm doing well, and yourself?
Pretty good. All right, so we're on the record in 26-00501. That is people of the state of Michigan versus Lene Crowley White. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people of the state of Michigan.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Lene Crowley White, who is standing to my right. Ms. Crowley White, if you could please state your first and last name for the record.
Lene Crowley White.
All right, thank you. This is time set for a final pretrial in the matter. Mr. Smith, how are we proceeding?
Your Honor, at this time, I will be asking that we set this matter for a jury trial. We do have the two complaining witnesses here. I've spoken with the defense counsel about this case. There may be a possible resolution to mental health court. We'll have to get Ms. Crowley White screened for that, but just in case she is not eligible for that, we'll be proceeding to jury trial.
All right, and is that a fair statement, Mr. Harris?
Yes, Your Honor. I was hopeful we could maybe set it for another final pretrial or some other thing to avoid potentially clogging up the court's docket. However, while we see if she's eligible, however, the prosecution is requesting this be set for a jury trial, then we can have it set for a jury trial.
How about which court is she looking? What specialty court?
Mental health court.
Okay, so that would be in front of Judge Hillman. That's 55th, right?
I believe so, Your Honor.
Yeah. So it would take some time to get the screening. So I would think, what, 4 to 6 weeks? Just in case, at least to get a determination.
Yes.
And then if the full, I know Judge Hillman takes a plea and all that. So, so we're probably looking at a jury trial date in July.
How about July 20th? Is that good?
Yeah, July 20th at 8:30. All right, we've set for jury trial on July 20th at 8:30, understanding that it takes some time for mental health to work itself out, or that specialty court to work itself out. And so Mr. Harris would be responsible for any type of petition to that court, but so we've built in some time. We've set it for July 20th at 8:30 for jury trial. Anything else for the record in 26-00501, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris.
That's the defense, Your Honor.
All right, Ms. Crowley White, we'll see you on July 20th at 8:30. Thank you for your appearance.
I just want to get a copy of the notice.
Who did you want to call next, Mr. Smith?
Mr. Mark or William File.
William File. And is that you, Mr. Harris?
Yes, Your Honor.
All right. And may I call those together, or do you want those called separately, Mr. Smith?
I would ask you to call them
Together? Okay. All right, so we're on the record in 24-00457 and 26-00635. That's people of the state of Michigan versus William File. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. William File, who is standing to my right. Mr. File, if you could please state your first and last name for the record.
William File.
Thank you. This is the time set for a final pretrial in the matter on both of these files. Let's see, 24-00457 and 26-00635. Mr. Smith, how are we proceeding?
Your Honor, at this time, the state will move to dismiss these cases. We have reached out to the complaining witness. In this case, she was served a subpoena. We do not have good contact with her. She was supposed to appear today and she's failed to do so. So the people moved to dismiss this case, both cases.
The defense would have no objection to a dismissal and in fact would request that the case be dismissed at this time due to the complaining witness's failure to appear. And I would request that a copy of the dismissal be provided to my client, Your Honor.
So based on the prosecutor's representations that the people are unable to proceed, the complaining witness has been subpoenaed and has failed to appear. And any contact with the complaining witness has been unsuccessful to get them to appear. We'll have printed out a nollie pros on 24000457 and a nollie pros on 2600635.
Dan, what's your P number?
88765.
Thank you.
And then we'll have Mr. Smith sign the nollie pros. So Mr. File, these are both being nollie pros without prejudice, which means that people could reissue if they choose to, but for our purposes today, the case is dismissed. I do not see. So this will be on 2400457, and then we'll have one printed out on 2600635 for Mr. Smith's signature. And then I don't have I have no contact order or GPS on the MDOP file. Thank you, David. Dave. And then on the DV file, I have a no contact with a Heather Vincent, but I do not have a GPS. So you should go on and get we'll give you a copy of these. It takes about 4 hours to purge from the court system.
Okay.
So you have a copy to identify exactly what we did here today.
Okay.
All right. So, all right, so I have signed the nollie pros on 2600635 and 2400457, and we'll provide a copy if needed. Anything else for the record in docket 2400457 or 2600635, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Mr. Fowle, you're all set. Thank you for your appearance today. All right, Mr. Smith, who's next?
Leroy Scott.
Leroy Scott.
Your Honor, Mr. Scott is right here, and I believe this is a final pretrial as well as a motion hearing on the
All right.
dog malicious destruction of property.
So it's 3 files and a motion. Okay. All right, so we're on the record in docket 2600973, 2600971, and 2600972. People of the state of Michigan versus Leroy Scott or Leroy Scott. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appearing on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Leroy Scott, who is standing to my right. Mr. Scott, if you could please state your first and last name for the record.
Leroy Scott.
All right, thank you, sir. This is the time set for a final pretrial on these 3 files and a motion. And is this Mr. Foreman's motion?
Yes, Your Honor.
Concerning
I'm
the Animal
capable
Control
of
Act?
handling it on his behalf.
All right. So let's go forward with the motion first to see, because we've kind of decided, we've kind of followed that motion. So Mr. Harris, you may make a motion, or this is time set for a motion. I think this is on 26009. 973.
Yes, Your Honor, this is at this point, the standard dog bite / dog MDOP motion my office has filed after the circuit court made their determination that Ingham County Animal Control and the Ingham County Prosecutor's Office does not have authority to criminalize the actions of dogs that bite when the dogs have not previously been adjudicated to be a dangerous animal. I would also note, as I would mention regarding the dog license and dog at large charges, there is also a question whether the dog even belongs to Mr. Scott. And so it's likely this would, it's likely we would potentially be fighting this if, fighting the dog MDOP, if it were not likely to get dismissed today. I would make the argument that since the prosecutor's office and animal control do not have the authority to issue this charge as decided by the circuit court, and as this court has agreed in multiple motions before, including as recently as last week, I would request that the dog MDOP charge be dismissed at this time.
And it's my understanding there was an appeal, and the appeal was denied by the Court of Appeals. Is that correct?
That is my understanding.
All right.
Additionally, I don't know if the Ingham County Prosecutor's Office has filed a response to this motion.
Yeah, I'm not sure. Mr. Smith, is there any updated case law concerning this matter?
No, Your Honor, I don't have any updated case law. I'm not aware of the status of the appeal, so the people would defer to the court or
Okay.
the motion on that motion.
I do have the final, this was on September 23rd of 2024. The application for leave to appeal was denied for failure to persuade the court of the need for immediate appellate review. That was signed by Godola. This is based on the circuit court opinion that was rendered by Judge Dragonchuk, retired Judge Dragonchuk, I should say. So without any further case law on the matter, and I'm not aware of any really. Again, I think we just ruled on this last week. I'm going to grant the motion to dismiss without prejudice, filed 2600973973, based on the motion to dismiss and the brief in support of the motion and the ruling that came from the circuit court, and then the appeal to the Court of Appeals. We'll dismiss without prejudice. I think this is on a ticket. Let's see. I can't remember. If it's on a ticket, it's on a ticket. Okay. So we'll dismiss without prejudice on ticket by Paul William, dated April 7th, 2026. All right, so that's all for the record at 26000973. And then on the two remaining files, 971 and 972, Mr. Smith, how we proceed?
Your Honor, I'd ask that these matters be set for jury trial. No, defense counsel has alleged that the dog may not be the defendant. I think that's a matter for the jury to determine. So I ask that the matter be set for jury trial.
Is there any paperwork concerning the owner of the position of the dog?
Your Honor, currently, and my understanding is that my client does not live at the address the dog was at. He was visiting a friend at the time, and was there. My understanding, there was multiple people in the home. He was simply the one who answered the door. My client does have paperwork showing where my understanding is that regarding where he lives. Regarding that, I think we might need some form of formal report, because the ticket doesn't indicate, it doesn't really indicate anything beyond the charge and where it's alleged, where it happened. I guess I would require, if the court is going to set a jury trial, I would either request that or a final pretrial for that, and to try and get some additional confirmation documents regarding the owner of the dog.
And this involves the Snooky,
Yes. My client has indicated the dog's name is actually, I believe, Snuggy, not Snooky.
okay, Snuggy. All right. All right, this was set for final pre-trial today's date. And we'll adjourn for further final pre-trial. And if we can get some verification concerning who is the owner of the dog, that'll ultimately be the case, because the owner of the dog in the future, if it comes back to this being the owner of the dog, then Mr. Scott will get the ticket. So we'll adjourn for further pre-trial for.
Is that 2 weeks?
It can be in that 2 to 3 week range, yeah. Whatever we've got.
June 29th.
Okay. Yes,
Aiken.
and it's just the end of the month. Yeah, it's 971 and 972. All right, we've set 2600,972 and 2600,971 for final pretrial, the adjourned final pretrial for June 29th at 8:30. And then we'll wait to see if there's any confirmation concerning the ownership of the dog for Mr. Scott. And then Mr. Scott, please keep in contact with your attorney, Mr. Harris, to provide him any paperwork we might need. All right. All right. Anything else for the record in 2600,972 or 2600,971, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Mr. Scott, we'll see you on June 29th. Thank you for your appearance today.
And this one was pre-trial, but you dismissed it, so you don't.
Yeah, we don't, that one's all dismissed without prejudice. That was the motion.
Thank you.
All right, Mr. Smith, what are we calling next?
Michael Wolf.
Michael Wolf. All right. All right. So we're on the record in 2601,016. That is People of the State of Michigan versus Michael Wolf. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, here on behalf of the people.
Mr. Smith, Mr. Smith and Mr. Smith. Yep.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Michael Wolf, who does not appear to be present in the courtroom or via Zoom, Your Honor.
All right. This was set for usually we'll leave these for the last, just to see, but he's an hour late, so this is fine. All right, so I do not see a Michael Wolf in the Zoom courtroom. There's nobody by that name in the physical courtroom. And he's not in the hallway based on the counsel's representations. I'm going to identify this Motorola on the Zoom courtroom. On the Motorola Moto G 5G, could you unmute and identify yourself? On the cell phone in the Zoom courtroom, you're on a Motorola 5G 2024. Can you unmute and identify yourself? All right. Nobody's answers by that name in the Zoom courtroom. We can remove the Motorola and then I bring him back when he identifies himself. So based on the representations of counsel, it would appear the defendants failed to appear today. As previously indicated, this was set for 8:30. It is now 9:29. And Mr. Smith, how did you want to proceed?
We asked the court to pinch for.
All right. This is a stolen property case. I don't have any previous bench warrants on the matter. Mr. Smith, how did you response?
I respectfully request the court allow a 48-hour hold. It is uncharacteristic for Mr. Wolf.
All right, I have no previous fail to appears in it, what appears to be a non-assaultive case. I will issue a bench warrant with a 48-hour hold.
Thank you, Your Honor.
Anything else for the record in docket 2601-016, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Smith.
Nothing for defense.
All right, thank you. We're all set. I don't know what happened. Oh. All right, I'm gonna miss the Motorola and then we're gonna once again. Find out who they are.
We're calling.
All right, on the cell phone, I've just admitted you into the Zoom courtroom. Can you please unmute and identify yourself? On that Motorola Moto cell phone, I just let you in the Zoom courtroom. Can you unmute and identify yourself?
Your Honor,
What's your name?
Christian Lee Collins. I'm a witness for a case. I'm not the gentleman. My name's Christian Lee Collins.
All right, what case are you here on, sir?
I'm here on the case for Danielle Nicole Guro.
Okay, all right.
And I'm sorry if I'm having trouble. I've never used Zoom before, and my daughter. I'm having her help me. I'm sorry.
No worries, no worries. I'm gonna have you changed over. And, all right, thank you for identifying yourself.
You're welcome.
So, Mr. Smith, which case next? We have Garreau, we have Heard, and then we have some 9 o'clocks.
Is there also a Jakia Mason on there?
Mason. I don't have a Mason.
It's Mason right here.
I don't have it on the docket. I don't have a Jakia Mason on the docket.
Okay, that's
Oh, I do. I have it. I have 1, 2, 3, 4, 5, 6 down. Jakia Mason.
I believe for the 8:30 hour, I would still, at least myself, I would still have a Miss Mason, I believe a Dolores Davis, and a Jimmy Hurd.
I have Heard. I have Mason. I don't have Davis. See a Davis on there? Yeah. I don't see a Davis. So did you want to go on Miss Mason?
I'm ready to go on Miss Mason if the prosecution is, Your Honor.
All right. And Mr. Smith, are you ready to go on Jakia Mason? Set for final pretrial today. Is 1, 2, 3, 4, 5, 6,
Yeah, I can see.
7 from the top. All right, Miss Mason, you can come up here. All right, so we're on the record in 2600915. That's People of the State of Michigan versus Jakia. Is it Janiah Mason? Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Jakia Mason, who is standing to my right. Ms. Mason, if you could please state your first and last name for the record.
Jakia Mason.
Thank you. And it's Jakia.
Yes.
Thank you. This is the time set for a pretrial in the matter, final pretrial. Mr. Smith, how are we proceeding? Would you like to defer to Mr. Harris?
At this time, I'll defer to Mr. Harris.
Mr. Harris, how are we proceeding?
My understanding, Your Honor, I don't believe we have any complaining witnesses, which I believe might be necessary to proceed with the case. If that is in fact the case, I would request the case be dismissed at this time and a copy of the dismissal provided to my client.
All right, Mr. Smith, how are we proceeding?
Your Honor, at this time, we ask that this matter be adjourned. I believe I sent the defense counsel an offer for this case to be sent to diversion, actually. So we ask that the matter be adjourned. We'll make that offer. I believe this is the defendant's first misdemeanor charge on her record, so our office would offer diversion in this case. So
All right, so
Your Honor, if I may,
you may.
I understand that there's an offer on the table. However, this is set for a final pretrial today, and my understanding from reviewing the charge is that there likely would have been lay witnesses who were subpoenaed to appear for this case today. If there were in fact subpoenas set out and those complaining witnesses did not appear, regardless of what the offer is, I would ask that the case be dismissed. If for some reason the case is proceeding, we can certainly consider an offer. However, if the case is getting dismissed today,
I'm the only
My
one who
thought
dismissed the case today.
I understand, Your Honor. I'm simply asking if as is usually the case in this court, and as this court has usually made a practice of, if there were lay witnesses subpoenaed for a final pretrial today and those lay witnesses have failed to appear, I would make the argument, as the court has done multiple times today, that would be an indication the Ingham County Prosecutor's Office is unable to proceed with the case, and I would request the case be dismissed.
All right, and this comes out of a diversion reject.
yeah, yes, Your Honor. I believe the defendant had an open charge at the time. Our office did not move forward with that charge. So at this time, once that other charge went away, she's now eligible for diversion.
All right, and this is a larceny by conversion, so it's not an unusual case. It looks like the apartment complex filed or at least made the report. All right, so let's set for an adjourned further pretrial. See if we can't, but somebody will have to be here from if this is going to final pretrial, somebody would have to be here from Continental Management.
Your Honor, can I confirm for the record whether or not a subpoena was sent out to someone from Continental Management, and whether someone failed to appear for that final pretrial today?
Yeah, Mr. Smith, was anybody subpoenaed today? Is that the complaint is the complaining victim is Continental Management, but I don't know if they were sent a subpoena and then who's responsible for. Looks like the manager was Lori Hall.
I don't believe Lori Hall was subpoenaed, Your Honor.
Okay. All right, without that subpoena, Mr. Harris.
I would simply ask, is there a reason why she was not subpoenaed for the final pretrial today? If one is known?
I don't know.
I don't know.
So we'll set for adjourned final pretrial for, and this is a larceny by conversion. It's not an assaultive matter. We'll set for the adjourned final pretrial for, we can probably go 2 weeks subpoena. So anytime after 2 weeks.
June 29th at 8:30.
June 29th. At 8:30. For the record, there has been a diversion offer in the file that was not, looks like a diversion reject. And then it has been reoffered at this date. The diversion, of course, you know what diversion is. Diversion is as a kind of the prosecutors comes out of the prosecutor's office. it doesn't end up in a warrant, okay? So, but that is the offer at this time. So June 29th at 8:30 is the final pretrial reset for. Anything else for the record in docket 26-00915, Mr. Smith?
Nothing wrong with people, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, Ms. Mason, we'll see you on June 29th at 8:30. Thank you for your appearance today.
Thank you.
And then Mr. Harris, you had is it Heard?
Mr. Hurd is here.
All right.
He's been brought up, Your Honor.
All right, have you had the opportunity to speak to Mr. Hurd?
To believe I believe I have spoken with him previously, and I believe this is an assaultive case with no witnesses present, so
All right,
it may be a quick communication if that is in fact the case.
all right. So, Mr. Smith, do you have to check to see if you have witnesses on this final pretrial? Or are we ready to go on Mr. Hurd? It'd be Jimmy Lee Hurd.
Oh. I think we're ready to go.
All right, so we're on the record in docket 25-02944 and 26-00307. That is people of the state of Michigan versus Jimmy Lee Hurd. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecutor Attorney Dan Smith appearing on behalf of people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Jimmy Hurd, who is standing to my right. Mr. Hurd, if you could please state your first and last name for the record.
Jimmy Lee Hurd.
All right, thank you. This is the time set for a final pretrial today. Mr. Smith, how are we proceeding?
Your Honor, I asked that this matter be set for a jury trial. At this time, after reviewing the file, reviewing the documents in the record, and the fact that Mr. Hurd has an additional domestic violence case, but the people intend to file a motion to proceed under the domestic violence statute and introduce Mr. Hurd's previous domestic violence as evidence in the trial. So we asked this matter, and the complaining witness is houseless at this time, so we haven't been able to reach out to her, but the people believe that we can make our case in that the complaining witness absence. So we ask that this matter be set for a jury trial.
So
Your Honor,
was Ms. Phone's subpoena today? And
Subpoenas.
were you able to subpoena Ms. Phone's?
A subpoena did go out, Your Honor, but from what my understanding is, and after reviewing the body camera, she lived in a tent. So I'm not sure if she received a subpoena or not, but again, it's our position that we're able to make this case without that complaining witness.
Your Honor, if I may.
You may.
From my review of the police report, I'm not necessarily sure how the Ingham County Prosecutor's Office would be able to proceed without the testimony of Ms. Phones, as to my knowledge, I don't believe my client made any statements regarding the domestic relationship or regarding the facts. So my understanding is the only person who could potentially testify with personal knowledge as to what occurred on that day would, if my client chose to remain silent, as is his right, would be Ms. Phones. The police officers would likely not be able to testify as to that without potentially violating hearsay, as they do not have personal knowledge of what transpired. I understand there's some concern about whether or not she received the subpoena. However, if she was unable to receive that subpoena and be here for the final pretrial today, I would make the argument that it seems rather likely she would fail to appear for the jury trial as well. And as far as I can tell, I don't see how the prosecution could proceed on this case without violating hearsay rules and my client's right to confront his accuser
Right, there,
at the jury trial.
we have a but I do want to see if the prosecutor is able to get missed phones here. And then we have a two-prong issue. One is confrontation, the Fifth Amendment, and then we have a hearsay issue concerning this matter. So there's some issues concerning the hearsay issue and then the confrontation issue, which is completely different. That's pursuant to the Fifth Amendment. I'm going to set this for jury trial concerning this matter. Is there another pending DV file on because we have 2502-944 and 2600-30307. Is there a third pending file?
Just the two DVs.
All right. So I'm going to set both of those for jury trial for. We'll set them fairly because the defendant is incarcerated, so let's set them this month. Yeah. But as long as it's 2 weeks, their subpoenas are 2 weeks. But if you're unable to subpoena her, then we kind of have one of our issues.
Yes, I think, Your Honor, I'd be fine. Can we get a little bit extra time? Because I would like to file a motion under 768.27B and 27C.
There definitely is, that'd be under the domestic violence statute. But I don't want to leave Mr. Hurd incarcerated.
I would request as soon as possible, Your Honor, and I would also likely be submitting a response to that,
Right.
indicating that I don't have it directly on hand, but I believe there is some indication that just because evidence can potentially come in under the hearsay rules for 27C, it does not
make a confrontation issue.
It does not defeat the confrontation clause issue.
Confrontation is under the Fifth Amendment. It's completely different than the hearsay. But we'll have to build in some time just so you get a chance to respond. So
2 weeks is June 22nd.
So what date are you using for the jury trial date?
Well, we don't have any jury trials on that.
Okay. All right, let's put it on the 29th. So June 29th, we'll set it for jury trial, and then I'll entertain at least a motion concerning a response before the 29th date. Mr. Harris would probably need about a week, so we should probably get him the motion by the 22nd, and then he'll have a week to respond. I think that's fair, about a week to respond, and then I will entertain a response to the motion and any response to the response up until the 29th. Okay. All right, so we've set this for jury trial on 2502-944 and 2600-307. We'll entertain motions beforehand. We'll get the motion, the response from Mr. Harris sometime before June 29th, and then that means that he should probably get the motion by the 22nd. Anything else for the record in 2502-944 or 2600-307? Mr. Smith.
Another from the people. Your Honor.
Mr. Harris.
From the defense, Your Honor.
All right, Mr. Hurd, we'll see you on that June 29th date. Thank you for your appearance today.
Take your shot.
All right, and then
Authors off the table.
how about Danielle Grow?
Right.
All right. And that's you, Mr. Doyle?
Yes, sir.
All right. How are you, Mr. Doyle?
Good.
I know where you were Friday afternoon.
Yeah.
In this courtroom. So we're on the record in 2500-863. That's People of the State of Michigan versus Danielle Grow. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appear on behalf of the people.
Mr. Doyle.
Good morning, Your Honor. Dan Doyle appearing on behalf of Mr. Guerrero, who is present and standing to my right.
And ma'am, you are Danielle Nicole Grow, is that correct?
Yes, sir.
All right, thank you. this is the time set for a final pretrial in the matter. Mr. Smith, how are we proceeding on this matter? Would you like to defer to Mr. Doyle?
The people would ask that this matter be set for a jury trial. We do have a eyewitness testimony, an eyewitness who's here. I believe he was on the Motorola device that you allowed to come into the meeting room. He received his subpoena late, so he wasn't able to appear in person.
But you do have a witness.
But yes, he
All
is
right.
here, and we ask that this matter be set for jury trial.
All right. Is that your understanding, Mr. Doyle?
Yes, Your Honor, that is my understanding. I do believe that the complaining party failed to appear. I don't know if he was subpoenaed, but that would also cause issues. But at this point in time, we will continue to jury trial.
All right. All right. So we'll set for jury trial on that 29th date. Okay. Sure. So we'll set for jury trial on June 29th at 8:30 or 8 o'clock. 8 o'clock. 8:30. Okay.
It is.
So we'll set for jury trial at 8 o'clock on June 29th. Anything else for the record in 2500863? And Mr. Smith.
Nothing from the people, Your Honor.
Mr. Doyle.
Your Honor, is it possible to get another date for the jury trial? I do believe
We can go, I think we can go, you know, and I didn't even ask about your schedule. I think we could go either 1 week before.
Yeah.
We could go the 22nd, or we can go, I don't think we can go the 1 week after, because that's right in the 4th.
And the 29th should work.
All right, so June 29th at 8 o'clock. All right, Ms. Groh, we'll see you on June 29th at 8 o'clock. Anything else for the record in 2500863, Mr. Doyle?
No, Your Honor, thank you.
All right, we'll see you on June 29th at 8 o'clock. You can get a notice from my court officer. Thank you, ma'am. Yeah, let me identify
Oh, no,
them.
no, no, hang on.
Is Crumley? Okay,
You talked to him, right?
Yeah.
Yeah, he's here for,
so we're gonna reschedule.
She was asking.
I don't know. Mr. Smith, do you have Mr. Gorney on your list? I don't have him on the docket.
who's that?
Matthew Gorney.
I don't have it, Your
All
Honor.
right,
I'm gonna email him.
all right. Well, if he's not. So, Mr. Gorney, you can unmute.
Yes, Your Honor.
All right, Mr. Gorney, I don't have you on the docket, so you probably should contact your public defender on the case, who's Melanie Wanchi.
Yep. Okay. Yeah, because I'm currently at Bear River Health.
Bear River, correct.
For residential treatment, and I called the courthouse this morning, and they advised me that it was at 9 a.m. So I'll contact Melanie Wanji and
Right.
see what she's
It'll be-
got going on.
It most likely be rescheduled,
Okay.
but I don't.
Asking for it.
Yeah, so it'll most likely be rescheduled. Get with her, and then we'll put it on the docket for a good date for it to be rescheduled. All right.
Okay. Thank you.
All right, you're all set, Mr. Gorney. Thank you.
All right. Bye.
Your Honor, is there any way that I'd be excused from this now?
Yes, you're here on Miss Garreau. Is that correct?
Yes, sir.
All right. So we've what we've done is set that for jury trial, and you should get a subpoena from the prosecutor's office. You should be all set.
Okay, now for the jury trial, should I show up in person or do the Zoom thing
Yes,
again?
that'll be live in person.
Okay, thank you, sir.
You're all set. Thank you.
Thank you, bye.
So, sir, you are Joseph Crumley.
Yes, sir.
All right. And ma'am, you are Jessica Redmond. Is that correct?
Yes.
All right. On Joseph Crumley. All right, so we're on the record in docket 260138. That is People of the State of Michigan versus Joseph Crumley. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Joseph Crumley, who appears via Zoom, who appears via Polycom from ICJ. Mr. Crumley, if you could please state your first and last name for the record.
Joseph Crumley.
All right, thank you. And you can hear me all right, Mr. Crumley?
Yes, Your Honor.
All right, thank you. This is time set for a pretrial in the matter. Mr. Smith, how are we proceeding?
Your Honor, I ask that this matter be set for a final pretrial.
And is that a fair statement, Mr. Harris?
Yes, Your Honor. At this point, I would request, I've spoken with Mr. Crumley regarding our options, and we would request a final pretrial date be set by the court.
All right, we'll set a final pretrial for. We'll need at least 2 weeks for subpoenas. June 29th at 8:30 for final pretrial in this matter. Anything else for the record in 260138, Mr. Smith?
Nothing wrong with the people, Your Honor.
Mr. Harris.
Nothing from the defense, Your Honor.
All right, you should be all set, Mr. Crumley. We've set it for June 29th at 8:30. Thank you for your appearance today.
Thank you, Your Honor.
And then you said, who else, Mr. Harris?
Mr. Cheryl Nance here, Your Honor.
Cheryl Nance. All right, Miss Nancy, you can come up.
Only if it's scheduled public credit later. So,
Being is set for 9.
Levine, Benjamin.
Your Honor, Mr. Levine, I believe.
I don't have him in custody. I have him out of custody. Crumley, Redmond, and then the 130s are in those. So let's go on Miss Nance, right? All right. All right, so we're on the record in docket 26013999. That is People of the State of Michigan versus Cheryl Nance. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith here on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Ms. Cheryl Nance, who is standing to my right.
All right, and ma'am, you are Cheryl Arlene Nance, is that correct? All right, thank you. This time set for a pretrial in the matter. Mr. Smith, how are we proceeding?
Your Honor, at this time, I ask the matter be set for a final pretrial.
Correct, Your Honor. I spoke with my client regarding our options, and she has indicated, well, and we both indicate that we request a final pretrial at this time.
All right, we'll set for final pretrial on. It's gonna be June 29th. We just don't. At 8:30, okay. So we'll set it for final pretrial for June 29th at 8:30. Anything else for the record in 26-01399, Mr. Smith?
Nothing from the people. Your Honor.
Mr. Harris?
Something from the defense, Your Honor.
All right, ma'am. We'll see you on June 29th at 8:30. Thank you for your appearance today.
Thank you.
Regarding Levine, Your Honor. So, regarding Levine, Your Honor, I did check the jail roster from this morning, and he was last week, he is still in custody at Bingham County Jail.
All right, I didn't have him highlighted. So we know so whether he's been brought over or not is another thing.
Yes.
Is
Well, if he wasn't highlighted, my guess might be that he may have been missed.
all right. Well, let's leave Mr. Levine, and I'll let you. How about who's here on Redmond?
That's my case, Your Honor.
All right. Are you ready to go on Miss Redmond?
Yes.
All right. And then we'll take a break because then we have Christensen at 10:30, and
That's a show cause.
yeah. Oh, is it? Yeah, that's a show cause. I bet Levine hasn't been brought over.
I'd have to go and look.
Yeah. Yeah, so we'll check. We'll take a break after these two cases and check on Mr. Levine, and then really we had a very manageable docket this morning. All right, so we're on the record. First of all, can I call these two cases together, Mr. Smith?
Yes, Your Honor.
All right.
No objection.
All right, so we're on the record in 25-00629 and 26-00817. That is People of the State of Michigan versus Jessica Redmond. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith appearing on behalf of the people.
Mr. Smith.
Tyler A. Smith from the Office of the Public Defender here in Ingham County. I do appear on behalf of Ms. Redmond in both cases.
And ma'am, you are Jessica Redmond, is that correct?
Yes, Your Honor.
And you can hear me all right, Ms. Redmond?
Yes.
All right, thank you. This is the time set for pretrial on both of these matters. Mr. Smith, how are we proceeding?
Your Honor, we ask that the matter be set for a jury trial. I think these are two retail fraud cases. And since there's the only complaining witnesses will be the store security, I ask this matter just be set for a jury trial.
So,
I may be heard.
yeah, you may, Mr. Smith.
Store security may believe that they're law officers, but they are lay witnesses as far as I am aware. So for that reason, as well as some concerns that I intend to address momentarily with regard to bond, I'd ask that we do set a final pretrial rather than moving immediately to jury trial.
Are you requesting that the prosecutor's office subpoena for final pretrial on both of these files?
Yes, Your Honor.
All right. Mr. Smith, of course, can make his request. I'm the only one who can dismiss the case, other than the prosecutor's office, of course, can not only prosecute the case. But we'll see. We'll set it for final pretrial and then work that from the. I believe one of these is from Target, and that's on 25-00629, and then one is from Meyer. Let's see. But I'll give Mr. Smith the opportunity to talk to his witnesses. All right. All right, so we'll set for final pretrial on June 29. I'm assuming there's restitution on both these files. Anything else, Mr. Tyler Smith, on behalf of the defendant?
Yes, Your Honor, I would like to address bond.
She's not being held on either one of these.
I don't believe she is. I just wanted to ensure that on the 629 file, originally there was a cash bond. I just wanted to ensure that that's no longer the case. It's being a misdemeanor. I think it should be PR, but
I would think, let's see, that's a good question. She was initially given a PR bond And then she failed to appear in an arraignment. They gave her a 300 cash surety. That came from the magistrate. No,
I have in my notes that it was cash only. That may be incorrect.
I have cash / surety. I don't know what she said on the record. Let's see, but I don't have it at 300 cash. She has release on personal recognizance shall be ordered under the statute. So she checked that box.
Okay, so that should have converted to PR.
I would think it's been converted to a PR bond, but
It's been quite some time since that
Yeah.
was set. I suspect it may be a 55th case that's holding Ms. Redmond in
Yeah.
custody, but I want to make
'cause
absolute.
that was set. She was released on PR shall be ordered as of May 22nd. So she might be being held on a 55th. Yeah, on another file.
Okay.
Yeah,
So
but
it doesn't appear that there's anything holding her to.
Yeah, right now I have a PR bond. If it is a cash bond, let me know and we'll work it out.
I'll confirm.
Okay, but so we've set it for final pretrial on June 29th at 8:30, and it's my understanding you're not being held on any one of these files, Ms. Redmond, okay?
Okay.
All right, anything else for the record in 25-00629 or 26-00817, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Smith,
Not for the record, Your Honor. Thank you.
thank you.
You'd be surprised to know, Your Honor, we're actually brothers.
Yeah.
Strong resemblance.
We kind of joked about it this day because I don't think anybody's as tall as Mr. Smith.
You got the better genes.
Question for Judge. So I called the jail and they can put Mr. Levine, they're gonna call him Mr. Levine, so we'll have to adjourn it.
Okay,
And then Mr. Christensen's out in the hallway. Do you mind?
we can do Mr. Christensen
Yeah, 'cause
now.
he's here.
Yeah.
Yeah.
Mr. Christensen's been here since this
Yeah.
morning. All right, let's put Levine on because I don't think they're gonna put him on Polycom, and so we can just adjourn that matter.
No, he just said that they're gonna try
Sorry
to
about
put
that.
them on.
But hopefully we'll-
Oh, I thought David just said that they weren't putting him on
No,
Polycom.
they are. They're
They're
gonna call
gonna
him.
put him
Yeah, they're
Polycom?
gonna call him. Yep.
Oh,
They said they rounded them up, so they said they should be
All
momentarily.
right, and is that Mr. Smith or Mr. Harris? Because you probably want to meet with Mr. Levine.
That would be me, Your Honor.
All
I've
right.
already met with them.
All right. All right, let's see if we can put him on, and then we'll go on Christensen.
Might be doing motions for persons.
Because they,
Did you say Levine?
They're gonna.
yeah,
they
they're
rounded
gonna
him-
try to put him on Polycom.
Yeah.
Yeah. All right, Mr. Christensen, you can come up here. All right, so we're on the record in docket 25-011-184. That's people of the state of Michigan versus Brian Christensen. Appearances for the record. Sir, you are Brian Christensen, is that correct?
Yes, sir.
All right, thank you. This is the time set for a show cause today. What's the total amount? I've got 275. Figure out what the cost of how much we have. 275. All right, I have a debt of 275 to the city of Lansing. It would appear that you need some time to make that payment. I can give you 90 days.
Okay.
Okay. And then we'll quash there will be no bench warrant issue out of that. So because you appeared today, okay?
Trying to get an LG solutions.
Okay.
So.
All right. So we'll set it up for $275 for 90 days, which would be September 3rd. So as long as it's all paid or start to be paid by that September 3rd date, that'll keep you out of the show cost cycle because you're unfortunately caught in the show cost cycle. You can kind of make your own payment plan, so you can pay $5 a week till you can. As long as you keep in contact with the city of Lansing, I don't think they're going to show cost you. Okay.
Okay. All right. Thank you.
Yep, and that'll keep you out of the warrant and having to come to court. All right, we've set it for September 3rd, 2026, for the $275 debt. And then we won't issue a bench warrant at this time. Anything else for the record in 25011184, Mr. Christensen?
No, sir.
Okay, you should be all set, sir. Thank you for your appearance
Thank
today.
you. You have a good day.
You too. I just put down as an extension. Oh, I bet you this is Mr. Levine.
Yeah.
Yes, sir.
Oh, that kind of worked out. And sir, you're Benjamin Levine?
Yes, sir.
All right. All right, so we're on the record in docket 2601420. That's People of the State of Michigan versus Benjamin Levine. Appearances for the record, Mr. Smith.
Andrew Decker on the record for the people pursuant to MCR 8120.
All right, so there's a motion to proceed. I assume Mr. Smith is the managing attorney.
Yes.
All right. You only have to make that motion once in this court, okay? So that's granted, and it's Decker, right?
Yes.
All right, Decker. All right, Mr. Harry's appearances for the record.
Assistant Public Defender James Harris here on behalf of Mr. Benjamin Levine, who appears via Polycom from the Ingham County Jail. Mr. Levine, if you could please state your first and last name for the record.
Benjamin Joseph Levine.
All right, thank you. And once again, sir, you can hear me all right, Mr. Levine?
Yes, sir.
All right. This is the time set for a pretrial in the matter. Mr. Decker, how are we proceeding? Would you like to defer to Mr. Harris?
I'd like to move for a final pretrial, and I would also like to note that the complaining witness is here, so I'd like to waive all future appearances for him.
All right. So we've set for, is that a fair statement, Mr. Harris, at least in regards to the final pretrial?
Yes, Your Honor, I would request that the final pretrial be set at this time.
So in regards to this matter, you will not get a subpoena since you're here on this date. You won't get and I'm going to say no witnesses are needed. All right, and we'll set it for final pretrial on June 29th at 8:30. Partly reading my mind right now. All right, we've set it for June 29th at 8:30 for final pretrial. We don't, there will be no witnesses subpoenaed by the people. I've written that in the register of actions. All right, sir. Anything else for the record in 2601420, Mr. Decker?
Nothing further, Your Honor.
Mr. Harris.
Nothing for the defense, Your Honor.
All right, Mr. Levine, we'll see you on June 29th at 8:30. Thank you for your appearance today. You should be all set.
Okay. All right. Can I speak to my attorney?
So, Mr. Levine, I can place you in with your public defender, Mr. Harris. That's close to 1. So I'll put you in room 1, and then you're all set after you meet with your public defender. All right, then, Mr. Harris, when you join us, I'll place him in a room with you.
Maybe they have you muted. Check. Yeah, they just have you.
Oh, deputy, stop.
Thank you.
I gotta take a leak. Is there a place where I can take a leak real quick? All right, so is there a place where I can take a leak real quick?
Check with medical. Real quick.
Want me to come up? Yeah. Oh.
Ms. Rogers, you can unmute. And we'll call your case. All right. So we're on the record in docket 25-01118. That's People of the State of Michigan versus Caitlin Rogers. Appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appear on behalf of the people.
Mr. Harris.
Yes, Your Honor. Assistant Public Defender James Harris here on behalf of Ms. Caitlin Rogers, who appears via Zoom. She, as I indicated off the record, she apologizes for not being here in person, but came down with a pretty severe illness. Her and her family did. She asked me over the lunch hour if she could appear via Zoom to avoid getting anyone here at court sick. I advised her that it would likely be better than not appearing at all. So she does appear via Zoom, with apologies to the court for not appearing in person.
All right, ma'am, you are Caitlin Rogers, is that correct?
Yes, sir.
All right, thank you. And you're appearing via Zoom, the Zoom app, is that correct?
Yes, sir.
It's my understanding that you've been taken ill, and so I would think that it's your request or your attorney's request to adjourn this.
I believe we could actually go forward, Your Honor. The recommendation
I can't because the recommendation is for jail.
Recommendation is time served, Your Honor.
Probation is not revoked due to the amount of jail time served on the case. It is recommended that sent to a term of incarceration with credit for time served. In addition, it is recommended that all financial obligations be paid within 365 days.
Yes, my reading of this is it is basically a time served fines and costs sentence.
On the retail fraud, what's the time served?
It's looking like 31 days, Your Honor.
All right. I'm willing to do a time served on this. That's Miss Rogers, you want to go forward with the sentencing and you've had the opportunity to see the pre-sentence report, or at least to go over it with your attorney. Is that a yes, ma'am?
Yes. I'm sorry. I'm
all right.
Voice.
I understand. All right. So with that understanding, I'm just going to follow the recommendation. Okay.
Understood, Your Honor.
All right. Is there any restitution on this matter that you're aware of, Mr. Smith?
Not that I'm aware of, Your Honor.
All right.
I'm not aware of any restitution.
Yeah.
I don't see any mention in the file.
I don't see it either. All right. We've kind of put the horse before the cart, but Mr. Harris, you've had the opportunity to go through the pre-sentence report with your client. Any additions, deletions, or corrections?
The defense would not have any additions, deletions, or corrections at this time, Your Honor.
All right, allocution, Mr. Harris, although you've kind of said some of it already.
Understood. Regarding Ms. Rogers, it does sound like Ms. Rogers, when she was speaking with probation, did admit to the charges and did admit feeling remorseful, and that she does not largely remember the incident due to the influence of multiple substances. She is, Ms. Rogers has since been trying to resolve those issues. She's been seeking treatment for that substance use since her release or incarceration. She's trying to get back on the straight and narrow, Your Honor, and is apologetic for the action she took while she was under the influence. I would simply request that the court follow the recommendation of probation and sentence her to time served. Regarding given her indigent status and limited resources, I would ask if the court would consider minimizing any fines and costs ordered and giving her at least 90 days to pay those fines, or at least to get some sort of payment arrangement set up with the court.
All right, and this is for a guilty plea, I believe on, looks like August 5th, 2025. Is that your understanding, Mr. Harris?
Yes, Your Honor.
All right, Ms. Rogers, is there anything you'd like to say to the court before the court passes the sentence?
I just deeply apologize for my actions.
All right. Well, Ms. Rogers, you're not a kid, and I'm not going to treat you like a kid. This is for a guilty plea to retail fraud, 3rd August 25th, 2025. It is the sentence to the court that you spend 31 days in jail. Credit is given for 31 days previously served. For the 90-day misdemeanor of She said she pled to actually to an attempt to retail fraud, I
Yeah,
think.
so I believe that should be half that. I think. It was
Yeah, so,
around the realm of like
250.
47 days and or
Yeah.
250.
all right, so I'm gonna waive any fines and costs. I'm gonna waive the crime victims' rights fee. And I'm gonna waive the state fee. So there's nothing, you've served your 31 days in jail, 30 credits given for 31 days previously served, and the total is 0 on the amount owed. So Ms. Rogers, this case you should be all set on. I can't speak to anything else you got going on. It looks like you might have something, I don't know, you have got a felony in 37th District Court.
I'm taking care of it. I have court tomorrow for that.
What's that?
I have court tomorrow for that.
Okay, you have court tomorrow for that. Okay.
I
And then I don't know what else, but this case, this file should be taken care of with the 31 days in jail for credit for 31 on an attempt to retail fraud. Anything else for the record in 25-01118, Mr. Harris?
Nothing from the defense, Your Honor.
All right, Ms. Rogers, do you have any questions of me?
No, sir.
You should be all set, ma'am. Thank you for your appearance today.
Thank you so much.
So in the Ingham Jail Post 1, would you please identify yourself?
My name is Toby Radcliffe.
Radcliffe, okay. So you're here for your probation violation arraignment. And under the moniker of Ezel Reyes.
That's also an arraignment.
I believe that's, so you're here for your arraignment, Mr. Reyes. You'll have to unmute.
Hello.
All right. So you are Ezel Reyes and you're here for your 1:30 arraignment.
Yes, sir.
All right. Stand by. I'm going to call your case in just a second. All right.
Okay.
All right. If Dusty Mag is like is he 5'5", 5'4"? I can't remember. I know I've seen him.
Yes, Your Honor. I know he's been here before.
Yes. But you have not seen him.
I have not seen him, at least not today.
All right. All right. So we're on the record in 26-00102. That's People of the State of Michigan versus Dusty Mag. This is the time set for sentencing. I do not see Mr. Mag in the Zoom courtroom. There's nobody by that name in the physical courtroom, and the hallway is all cleared. So appearances for the record, Mr. Smith.
Thank you, Your Honor. May it please the court, Assistant Prosecuting Attorney Dan Smith, appear on behalf of the people.
Mr. Harris.
Assistant Public Defender James Harris here on behalf of Mr. Dusty Mag, who unfortunately does not seem to be here. I don't have any information regarding why there's the failure to appear, Your Honor. I have tried to contact him, and my office has also tried to contact him. I believe the last contact I have with him was the previous court date in April when the plea was taken, and at that point I had moved for a request for immediate sentencing, which was denied, and court set the sentencing date, which I believe was then reset once to today's date, and that puts us here. And fortunately, it does not seem like Mr. Mag has appeared here in person or via Zoom. I would request if the court might consider a 48-hour hold before a bench warrant or a courtesy reset. Otherwise, I would leave it up to the court's discretion.
I definitely am going to do it. I'm definitely going to consider 48-hour hold because this was set for May 18th and then we reset it. So Mr. Smith, how did you want to proceed on the fail to appear?
We defer to the court.
Okay. It would appear that the defendants failed to appear. I do not see Mr. Meg in the Zoom courtroom or physical courtroom. And this is not Mr. Meg's first appearance in front of the court. On other files I've had him. And he's always shown up. He's pretty good about always showing up because he's able to express himself well. So I am going to issue a bench warrant for his fail to appear, but I'm going to do so with a 48-hour hold. So if he's able to, if you're able to have any contact with him, let our office know, and we'll just reset the sentencing without the warrant.
Yes, Your Honor.
All right. Anything else for the record in 2600102, Mr. Smith?
Nothing from the people, Your Honor.
Mr. Harris?
Nothing from the defense, Your Honor.
All right. All right. I'll wait to hear from you, Mr. Harris. We've issued a bench warrant with a 48-hour hold.
Thank you, Your Honor.
Thank you, Mr. Harris. And then we'll go, I think that's all the sentencings. So, and then the rest are arraignments.
That's the case, Your Honor, yes.
So we'll do the arraignment. Thank you for your appearance today.
Thanks, Your Honor.
So, Mr. Radcliffe, let's call your case while we have you.
Okay.
So we're on the record in docket 2502415. That's people of the state of Michigan versus Toby Radcliffe. And sir, you are Toby Radcliffe, is that correct?
Yes, Your Honor, it is.
All right, thank you. And you can hear me all right, Mr. Radcliffe?
Yeah, I hear you. I hear you as well as the speakers are gonna work, yeah.
All right, this is the time set for probation violation. I'm going to read to you some of the allegations that have been made by your probation agent. And then I think what we'll have is do you have an out date, Mr. Radcliffe?
Yes,
we could have
June 25th.
Okay. For our purposes, we're gonna have somebody from the public defender come down and see you, and I'll give you their number. You might have to make financial application to them. They did represent you in the underlying file, and so you should definitely have. We're gonna set this for hearing. You definitely should have somebody, some legal representation on this file. Okay, sir?
What is this file? Oh, it's a probation violation?
Yeah, it's a probation violation, but this is only the arraignment, so we've set it within 14 days of the hearing.
Oh, because I don't know, I've been incarcerated for the last 20 some odd days.
Yeah, so tell the attorney who's assigned to that, we're gonna have him to come down and see you. The allegations are submitted by your probation officer on May 18th, 2026. It is alleged that you violated your probation in a technical format by failing to report to your probation officer on April 15th, 2026. You failed to test at AverHealth failed to open testing file at AverHealth, and you failed to provide proof of an appointment attendance at Community Mental Health. So those are the three reasons your probation has been violated by Mr. Hanna. If you're able to explain any absence to your attorney, then Mr. Hanna will be here, and but we're under by statute. We have to set this within 14 days. Okay.
Okay.
So you should be visited by somebody from the Ingham County Public Defender's Office. But those are the allegations. It's failed to report, failed to test, and failed to provide proof of appointment, attendance at Community Mental Health. I'm going to set this. So we'll set for actual probation violation hearing on what date?
All right.
It's
Yeah,
got to be within 14 days. Yeah.
All right, I've just been homeless, Your Honor. That's mainly what the problem is.
Right.
I've had no food or anything. So that's what the problem's been. My fiance got incarcerated and she had a phone.
Let's see. I think that should be fine, but let me make sure I've got. Yes, we can do the afternoon of 22nd. So So PM. What time?
Let's do 2.
2 o'clock. All right, and then we should make a note. I'm gonna have the public defender's office see Mr. Radcliffe if they haven't seen him, but we'll give him the date. So it'll be set for June 22nd at 2 o'clock, and then we will contact the Ingham County Public Defender to go down and see you because you're incarcerated on a probation violation, and we've set it within 14 days. We'll let them know all that, but they should come down to see you. Okay, sir?
Yeah, if I'm released before then, would I be released or am I gonna be held here till that court date?
If you're released before the 22nd, then you should be here on June 22nd at 2 o'clock.
Okay,
All right. All right. So we've reset it for June 22nd at 2 o'clock. You should be all set, Mr. Radcliffe. Thank you for your appearance today.
thank you.
Giselle Reyes. All right, Giselle Reyes, you can unmute.
Hello.
All right. All right, so I'm going to call your case, sir. We're on the record in docket 2502118. That is People of the State of Michigan versus Giselle Reyes. Appearances for the record. Sir, you are Giselle Reyes?
Yes.
All right. Thank you. You're here on a probation violation arraignment. I'm going to indicate to you the nature of the probation violations that have been alleged against you, and then some rights you have in this hearing. And we'll set the hearing within 14 days. I have that you were represented by the public defender on the underlying file. Is that correct?
Yes.
All right. I'm going to give you a number to reach out to the public defender so you can call them and to see if they can represent you on this file. Okay.
Okay.
All right. So it is alleged by your probation officer that you did there's a bunch of counts here, but there's really 2. It's listed at violation 14. That's just how we number them. That doesn't mean there's 14 violations. That you failed to submit to random testing at AberHealth on April 17th, April 23rd, and May 14th. That's the first allegation. The second allegation is you failed to attend moral recognition therapy at PATS on April 22nd, April 29th, and May 6th. Mr. Reyes, do you understand the nature of the allegations been brought by the probation department?
Yes, sir.
All right. We're going to set this for hearing within 14 days. That's what the statute requires. So you have a right to a hearing in this case. You have a right to legal representation. We're going to give you the name of the number of the public defender's office. It's a little different than arraignment. Arraignment, they show up and they defend you at arraignment. Here, you're going to have to reach out to them and tell them what date, so they can be expecting representation on that date. The date we're setting it for is
this probation violation?
Yeah, within 14 days. So the same,
June 22nd.
So June 22nd at 2 o'clock.
Can you say that one more time, please?
All right, so it's set for June 22nd at 2 o'clock. That'll be live in person on the 6th floor of City Hall of Lansing in front of Judge Flores. And then if you call the public defender's office, they will assign one of the attorneys who appear in front of me. That'll be either James Harris or Mr. Smith.
Okay.
And let me give you, do you want that number, that the Ingham County Public Defender's number?
Yes, sir.
All right. Yeah, it would probably be a good idea to call them right away. So you make sure you get the representation all lined up. The Ingham County Public Defender's number is 517-679-2979. 517-679-2979.
Okay, I got it.
All right, so I'll see you live in person on June 22nd at 2 o'clock.
Okay.
Anything else for the record? Do you have any questions of me, Mr. Reyes?
No, sir.
All right, I'll see you on June 22nd at 2 o'clock, and I would prioritize call them within the next afternoon to seek representation on this, because this is a violation number. But you've had other violations, so you're familiar with the process.
Yes.
All right. So I'll see you on that date. Thank you for your appearance today, Mr. Reyes.
Thank you.
And is there a representative here of Arthur Olivia? I don't see one.
Oh, Judge, we have Olivia Arthur, we have her here.
You have Olivia Arthur here?
Yeah, but I thought you were asking about if I had an attorney, so I thought you were saying I didn't have an attorney.
This is just an arraignment. I'll assign you an attorney, right?
Okay. Well, yeah.
Are you Miss Olivia?
Yeah.
All right. You can have a seat right there. So we're on the record in docket 2402862. That is People of the State of Michigan versus Olivia Arthur. And ma'am, you are Olivia Arthur, is that correct? All right. This is time set for a probation violation arraignment. It is alleged by your probation officer in a request and summons for probation violation, co-signed by Judge Buchanan. The allegation is displayed assaultive or threatening behavior at AberHealth on or around April 23rd, 2026. You understand the nature of the allegation, ma'am?
Yes, I do.
Okay. All right. You have a right to hearing. Okay. You have a right to counsel. We're gonna pursue the statute. We're gonna set this within 14 days. Okay. That'll be live in person on the 6th floor, and then the Ingham County Public Defender's Office. It looks like they were involved in the underlying case. So what I'm gonna do is I'm gonna give you a number and you can contact them. You have to make reapplication, but you should share this hearing date with them, okay? All right, so at probation violation arraignment, we'll set for probation violation hearing for, you can do June 22nd, that same one. 2, perfect. Okay, June 22nd at 2 o'clock. And David, do you have the public defender's number, or I can give it to her?
It's 679-6279.
Yeah, it's 679-2979.
297.
Yeah. So my court officer will give you the Ingham County Public Defender number. You should share that June 22nd date, just so they know, so they can have you represented at the hearing, okay? And it would be Mr. Harris or Mr. Smith would represent you. You can get that from my court officer. We've set it for June 22nd at 2 o'clock for hearing on the allegation. Can you think of any other questions of me, Ms. Arthur?
Can I make a statement?
I'd save that for the probation, for the hearing.
Yeah, I don't have any questions.
Yeah, all right. So that would be the number. I would prioritize that. And then make sure that the attorney that's from the Ingham County Public Defender's Office, make sure you talk to them about whatever statement you need to make. And then you can make a statement at hearing if you choose to. Okay. All right. You understand the nature of the allegations. It's for AberHealth behavior. You understand that?
I do, and I'm pretty not guilty.
All right. All right. I will see you on June 22nd at 2 o'clock, just like we are here. Thank you for your appearance today.
Thank you.
All right. Is there a Paris Mendenhall? All right, Miss Mendenhall, you can come up here. All right, Miss Mendenhall, this is the time set for a probation violation arraignment. All right, so it's people 20, we're here on 24-03-511. That's people of the state of Michigan versus Paris Mendenhall. And ma'am, you are Paris Mendenhall, is that correct?
Sure.
All right, thank you. This is a time set for an arraignment. I'm going to indicate to you the allegations have been alleged against you, and then we'll set it for hearing and we'll get you some representation. It looks like you were represented by the public defenders on the underlying file. Okay. It is alleged by your probation agent that he came and requested, it's co-signed by myself, but he came and requested on May 12th, 2026. One allegation is per AverHealth has failed to submit to your analysis as directed on April 22nd, April 27th, and May 5th of this year, and that you failed to complete an IOP. That's the second allegation. Do you understand the nature of the allegations that have been brought against you by your probation officer? Yes. All right. You understand that you have a right to counsel, you have a right to hearing in this matter, and we're gonna set that up now, okay? So you have a right to a hearing within 14 days statutorily, and so we are gonna set the probation violation hearing for June 22nd. At okay, 2:30. Okay, so your hearing is live on the 6th floor City Hall of Lansing, just like we are here for June 22nd at 2:30. You can get the public defenders. It's a little different. You'll have to apply for a public defender, reapply, and you should do so. Make it a priority. Call them this afternoon so they have this date. Okay, it's June 22nd at 2:30. You can get the date from my court officer concerning their phone number, and we've set it for June 22nd at 2:30. It'll either be Mr. Harris or Mr. Smith that'll represent you. Okay, ma'am?
Yes, sir.
All right. Do you have any questions of me, Miss Mendenhall? All right. Be here June 22nd at 2:30 live in person, and you can get the public defender's office from my court officer, Mr. Warner, Wormsley.
The phone number, right?
Yeah.
Yes.
Yes. You should be all set, ma'am. Thank you.
Thank you so much.
Mr. Boot, how are you?
I'm doing, Your Honor. We have some things. I spoke with Marcy and Mr. Wormsley about tomorrow. Spoke with Mr. Smith. He's on both of those.
Okay. He's on. They're both OUILs, aren't they?
Yes.
Okay.
One is IBAC and the other one has DWLS and no registration tied to it, I think.
Yeah. You probably have to wait for him if he.
I'm waiting. Mr. Green, who is the high BAC, is he likes to appear, but he does not like to answer his phone.
Okay.
And so they've had trouble contacting him. I know this court's position on the same day.
Yeah.
Negotiation. I was just kind of saying there might be one, but I know.
I'm on the drunk driving. I'm if you want to reduce it, that's fine. And I don't. He doesn't have a plea to the charge. The other stuff.
Yeah.
So if that's
we have an offer on that. That was a new offer as of last week.
All right.
He's having some. Just getting a hold of them.
Yeah, that's gonna be problematic.
There may be offers.
They have to show up first, and then
that's the first step. But if we have something set by day's end, we will let the court know.
All right.
I just wanted to let you know there might be a change in the morning, and we will alert you as soon as we can.
All right, that sounds good.
We may be having some fun.
All right, we'll see. We'll see.
Thank you, Your Honor.
Thanks, Patrick. You're not interested in all that fun?
I'm not so much interested.
Yes.
All right, let's see who's here for civil, because we have some. Let's see. All right, Miss Bonilla, you're here for your 2:30?
Yes.
Yes.
All right. And then we have, is it Trayvon Brooks? You're here for your 2:30 also, ma'am?
Yes. Yes.
All right. And then Miss Francis, you're here for 25078. you're here for Lansing 74 LLC.
Yes.
Okay.
Okay.
And then Ms. Haddad, you're here for Mr. Bouchard.
I am, Your Honor.
All right. Codrington 6068. All right, Christina Codrington, you're here on Lake Trust?
Yes,
Are you here for Lake Trust or for Mr. Gordon?
for Lake Trust.
All right, perfect. I'm just seeing who's in the Zoom courtroom right now. Miss Whitty, you're here on Old Time LLC?
That's correct. Thank you.
Okay. And then Mr. Smith, are you here for LAFQ?
Yes, Judge.
All right. And then it's 1301. Mr. Quinn, you're here for State Farm?
Yes, Your Honor.
All right. All right, let me see who else is in. Ma'am, what's your name?
Maria Rabideau, representing Lansing 74 Apartments. 15G.
Are you a property manager or are you with
Yes.
Mr. Gann? Your property
No,
manager?
yes, manager.
Okay. All right, you can have a seat. You're
Back
one of,
here?
yeah, you're
Okay.
one of 6 that we've
Okay.
got a call. And what attorney are you waiting for, ma'am? Are you waiting for Mr. Gann? Okay. T. Arena is not here. And then, sir, do you have a hearing today?
Yes, I do.
What's your name?
Last name is Gordon.
Judge, I'm
Charles
here for
Gordon?
Attorney Gann.
Yes, sir.
Oh, you're here. Oh, Miss Francis, you're here for Attorney Gann.
I am. I'm just on the record on another case if you could pass me.
All right, no
Thank
problem. Just, yeah, you're good. And then, so Mr. Gordon, you're here on Lake Trust.
Yes, sir.
Okay. I think that's your phone.
There's kind of some of the older phones have. Never know. I used to change.
And it's, I'll look for it too.
Yeah.
So,
Yeah, some of the.
but it's usually left to the end because it's the least amount of people here and we can move them out and then we can have a non-public hearing. Some probations are that way, some probations, some sentences. I think that's about it.
Yeah. Until I went out and I looked at the document here, and it says, now, shoot, somebody, but whenever we get out, I just keep saying, hey, is this? Okay? Just like, because some of the files.
All right, so we are on the record in 13-01108 GC. That's State Farm Mutual versus Maricela Bonilla. Appearances for the record
Good afternoon,
from
Your Honor.
State Farm.
Maxwell Quinn, P86016 on behalf of plaintiff.
All right, thank you. And then, ma'am, you are Maricela Bonilla?
Yes, Your Honor.
All right, and I also have, is Verzi Williams with you? I have Verzi Williams.
No, he's not.
All right.
I don't have.
And I don't have him on the docket either, but I have him on the party information. He's not on the docket, but I do have him as one of the parties. I have it. This is time set for a hearing in the matter. Mr. Quinn, have you had the opportunity to speak with Ms. Bonilla about this file? We had to stipulate to the motion, an agreement of motion. Order to file from D1 will sign for defense. State Farm appeared as plaintiff and D2 appeared as Verzi Williams, represented by Joseph Cooper. That was on June 23rd of 2025. And then we met again on April 21st, 2026. Mr. Quinn, how are we proceeding today?
Defendant did say she would file an order quashing the abstract. I did speak with her. After that conversation, I agreed that I would file it. I did file it. Unbeknownst to me, it was rejected just due to a MC97 issue with personally identifiable information. I was just in the process of resubmitting the order. I can just file that again and we should be all set if the court would like to just schedule another adjourn date.
Yeah, I would just set a control date, and as long as it's presented to me for signing purposes, and everybody's Ms. Bonilla, is that your understanding? It was sent, it was rejected for whatever reason, and now it's going to be resent again. Is that your understanding, Ms. Bonilla?
Yes.
All right.
All
right. So,
well, he told me that he was going to submit it, but I didn't hear anything further. But now I'm hearing that it's going to be resubmitted.
yeah, it's going to be resubmitted, and I don't. Since Mr. Quinn most likely is covering, it was probably not. It was not given to. It was not made known to him that it was not accepted for whatever reason, and this happens all the time, Ms. Bonilla. So that's why. So it's not unusual that this happens. Is that a fair statement, Mr. Quinn?
Yes.
All right. So I'll indicate that the hearing was held and P1 is to follow up with an order. We'll set this for control date, and then we'll wait to hear from you. If we don't need that control date, just call into my office and just tell them we don't need that date, okay? And that'll probably be once I sign it and get it back to you. All right, so the control date, I'm probably 30 days out. Yeah, just a hearing date, or we can redo this hearing. I mean, whatever's easiest. But July 6th. 2:30, and then so it'll be July 6th at 2:30 as a control date, and then you can let us know if that's already been signed, okay, Mr. Quinn?
All right, will do, Your Honor. Thank you.
All right. Anything else for the record in docket 1301108 GC, Mr. Quinn?
Not from plaintiff.
Ms. Bonilla, do you have any questions of me?
What is a control date?
It's it's to make sure that I get the paperwork. That's all we're setting it for. Because if I sign it, you're not going to need the hearing. If it's not signed, we can investigate why it's not being signed.
It's you who has to sign it, correct?
Yes, I have to sign it, but I don't accept that the electric filings the civil department does, and that might be part of the problem.
So you need you need the stipulation given to you in person?
No, I don't need anything right now. We've set it for control date, and I'm waiting for Mr. Quinn to refile it so that I can sign it.
And that's not going to be an issue, correct?
That's correct. It shouldn't be. It shouldn't be an issue. We just set it for control date just in case there happens to be an issue.
How long will it take for you to receive and accept it?
I couldn't answer that. Because I don't get it. I don't receive it. It's actually electronically given to me by the civil department. So we've set a control date for 4 weeks out just in case.
I think she's asking if she's in Florida.
Is there?
You don't have to be here in person. You can come via Zoom for the control date if you're out of state.
I just want to know when I can expect it to be signed so we could get this thing over with.
Yeah, I'd sign it as soon as it's presented to me. If Mr. Quinn sends it today, it'll be signed by the end of the week.
Okay. All right.
Okay.
Yeah.
All right.
Thank you.
All right. Anything else for the record, Ms. Bonilla?
No, thank you.
All right. Mr. Quinn, I'll accept the order to follow, and then I'll sign it on presentment. You should be all set.
All right. Thank you.
Thank you. Thank you, Ms. Bonilla.
Thank you.
Sorry. Stuff when I go from one to the other.
Thank you. Sorry.
All right.
Sorry.
No, you're fine.
Francis was here on game. All right, Ms. Coddington, I can call Lake Trust. Mr. Gordon, you can come up here. Yeah, you can have a seat right there. So right, so we're on the record in docket 25-06853. That's Lake Trust Credit Union versus Charles Gordon. Appearances for the record, Ms. Coddington.
Christina Codrington, P 889614 for the plaintiff.
Thank you, Ms. Codrington. And sir, you are Charles Gordon, is that correct?
Yes, I am.
All right, thank you. This is the time set for, I have it as a motion. We previously met on we previously set, is this a motion for summary disposition, Ms. Codrington?
Yes, it is.
All right. And we previously met on May 11th to allow the defendant some time to see the motion. Did either one of the parties want to speak before we get started on the motion? This is you're the plaintiff in the case, Ms. Codrington. Did you want to speak to Mr. Gordon, or do you want to just go forward with the motion?
I'd be open to speaking to Mr. Gordon if he's open to it.
Mr. Gordon, would you be open to speaking with Ms. Codrington, or do you just want to respond to the motion?
I'm welcome to hear what you.
All right. So so Ms. Codrington, Mr. Gordon is here. We're going to place him on an iPad. If you follow my court officer, yeah. If you follow, and then Once he joins, I'll place Ms. Codrington in the same room and you can discuss this before the hearing, okay? All right. So I'm going to indicate all parties appeared and to meet in a breakout room. Breakout room. All right, so Ms. Codrington, you'll get a prompt to go to room 1, and then I'll place the iPad in a room 1, and you'll have some privacy before the hearing, okay?
Okay, thank you.
You're welcome. What's the name of that? What is the name of that iPad that we're, the one I gotta look for?
The other one is not. They used it, so.
Is that Flores iPad or courtroom iPad?
No,
Or- All right. Once he joins, I'll. All right, so we're on the record in docket 25-07708. That is Old Time LLC versus Trayvon Brooks. Appearances for the record, Ms. Whitty.
Joy Whitty appearing on behalf of plaintiff Old Time LLC.
And ma'am, you are Trayvon Brooks, is that correct?
Yes.
All right, thank you. And is Trevor Brooks with you?
He is not.
Okay. All right, this is time is set for a motion today. We previously met on May 13th. Ms. Whitty, you're the moving party, but I don't know who's made the motion.
So we had an outstanding motion regarding the writ date in this case. We have a conditional dismissal and a default judgment happening. At this point, we still have a small balance left of rent to pay. One of the two defendants is out. So rather than move on our motion to extend the writ date, we would ask for one more control date and see if the whole matter will be wound up with the balance of the rent being paid in full and the second defendant vacated.
All right, and Ms. Brooks, is that your understanding? We'll be setting this for control date in the future just to see if we can wrap up the balance that's owed.
Yep, that sounds about right. And I spoke with my landlord today and said I was perfectly comfortable with setting a concrete date for everything to be handled by.
All right, so let's do this. Let's set it for control date. Control date. And then I'll wait to hear from you, Miss Whitty, if we actually need that date or not.
Sure.
Okay, and what time frame are we looking at here?
If we could send something toward the end of June, I think that would be best.
All right, so we can set it for June 29th.
Sounds great.
All right, June 29th at
What am I sitting for?
just you can adjourn this hearing.
So I'm another motion.
Or yes, that's fine. Okay, and we'll do it at 1:30. So we'll set this for a adjourned date of June 29th at 1:30, and then we'll let the parties negotiate up until then. And you can tell us if we need that date or not.
Excellent. Thank you, Your Honor.
All right. Anything else for the record in 2507708, Ms. Whitty?
Nothing further. Thank you.
Ms. Brooks, do you have any questions of me?
No, Your Honor.
All right. You should be all set, ma'am. Thank you for your appearance today. Thank you, Ms. Whitty.
Thank you.
Thank you.
And they can do
All right, Miss Navyet, you're here for Mr. Gann, is that correct? You'll have to unmute, ma'am.
Sorry, that's correct.
Okay. Right, and that is with an Angelique Tijerina, and there is also a property manager from Lansing 74 LLC. Is that correct, ma'am? All right. All right, so we're on the record in docket 25-07807. That is Lansing 74 LLC versus Angelique Tijerina. Appearances for the record, Ms. Francis.
Navjot Francis on behalf of plaintiff's attorney of record, Your Honor.
All right. This is the time set for a motion on the matter. Let's see what we previously set this. I don't have any notes on here. So I do not see an Angelique Tijerina in the Zoom courtroom. There's nobody here in the physical courtroom. Last we checked, there was nobody in the hallway. So this was a motion for an eviction. Ms. Francis, how are we proceeding today?
Your Honor, we did file a motion for a request for writ to enter. Defendant has not made any payments as they were supposed to or vacated the property, Your Honor. So we are asking for the writ to be entered.
All right. All right, so based on the defendant's fail to appear, this was scheduled for 2:30, it's now 2:58. And in the lieu of a default judgment that I think we all understand that Ms. Tijerina is not here, I will sign the motion to evict when presented to me. Ms. Francis, you'll follow that up with an order?
Thought there was a application submitted.
Yeah, there might be one already submitted. But if that's already submitted, that's fine. I will sign it for the default. I will sign the order. The defendant has failed to appear today. It appears. So I'll sign the order and grant you the motion to evict at this time.
I'll make sure
write that down.
I'll make sure they resubmit the order, Your Honor,
right.
the application.
Right. I may already have it. I just have to clean out the files, okay?
I understand.
All right. Anything else for the record in 2507807, Ms. Francis?
No, Your Honor. Thank you.
All right, you should be all set. I will verbally grant the motion and then wait the order to follow if I don't already have it. You should be all set too, ma'am. Thank you. You're all set, Ms. Francis.
Thank you.
All right, so we're on the record in the docket, back on the record in docket 25-06853. That is Lake Trust Credit Union versus Charles Gordon. And Ms. Codrington, did you have the opportunity to speak with Mr. Gordon in a breakout room?
Sorry, can you repeat that? It was breaking out.
Did you have the opportunity to speak to Mr. Gordon in a breakout room?
Did. We could not come to an agreement, so we're going to move forward with the motion for summary disposition.
All right. So the plaintiff has filed a motion for summary disposition. You may proceed, Ms. Codrington.
Plaintiff at Lake Trust Credit Union entered into an agreement with defendant Charles Gordon to provide financial services. This is evidenced in Exhibit 1 through the classic card application. This application, the defendant listed at the time his address, his work information, signed this application, and then he was provided with a credit card with a limit of $500. The card was used, payments were sent out, statements were sent to defendant's home at his current address where he lives at 1107 Fairway Lane in Lansing, Michigan. There were no objections to those statements at the time, but there were timely payments made after the statements were sent to defendant's home. However, payments did not continue and defendant defaulted on the terms and conditions of the agreement by failing to make payment as promised. Plaintiff filed this claim and the court issued the summoning complaint. Defendant filed an answer, and while vague, he disputes the balance and states that there was no clear evidence to support this claim. Defendant states that the evidence attached is not labeled and does not actually state what it is. However, Exhibit 1 is clearly labeled an application for a credit card. Exhibit 2 and so on, and the supplemental exhibits attached are also very clearly credit card statements that clearly list out past balances, payments and credits made, fees charged, interest charged, and how interest is accumulated along with annual percentage rates. And each statement attached has a shortened version of the card disclosure statements. We also served discovery requests upon defendant. Defendant did not respond to those. And pursuant to MCR 2.312, requests for admissions that are not responded to are deemed admitted. Defendant has offered no genuine dispute or defense to the claims other than stating that he does not understand or does not think that the exhibits are clearly labeled or they're ambiguous or not clear, but the exhibits are very clear. It's an application for a credit card that he signed up for, then following our statement that he received at his address that he currently resides at. There is no genuine issue as to any material fact, and plaintiff is entitled to judgment. Nothing further, Your Honor.
One question, Ms. Codrington. Did Mr. Gordon make any payments on the card?
He did.
And how many payments did he make?
I'd have to.
If you have that information.
I don't know how many payments he made. I can tell you the last payment.
When was the last payment made?
Pull that up. Sorry, I have a lot of credit card statements.
No worries.
The last payment IQBC made was on November 7th, 2022, in the amount of $40.
All right, thank you. Response, Mr. Gordon.
Your Honor, first of all, the plaintiff is attempting to mislead the court with a whole stack of ambiguous statements from Exhibit 1 through Exhibit 5. Starting with Exhibit 1, they're stating that I applied for a credit card with Lake Trust Credit Union. If you look at Exhibit 1 says nothing about Lake Trust Credit Union. It's a vague document with one is dated all the way back to 2000. Okay, and it states clearly, and she stated in her statement just now, it states Mr. Gordon applied for a MasterCard. Okay, and then as you go to Exhibit 2, it's a Visa. They got a bill here for a Visa, and all these charges with along with that with an account number attached to it. The account number for Exhibit 2 does not even coincide with the Exhibit 1 statement account. And then if you go to Exhibit 3, it's entirely another different credit card number that's a Visa. So based on Exhibit 1 right off the bat, there's something awry here, along with the amounts that you see on the credit card statements and the amount that they're asking for. They don't even coincide. If you do the math, it states here I owe over $4,000 and something on a credit card, but they're looking to collect $2,000. So in my opinion here, Your Honor, in the digital age that we're in with AI, I think they're looking to collect money on a past due account and trying to find someone to attach it to, and trying to drop it where the hat lands.
So this is your response.
That is my response, Your Honor. That this is not this amount that they're looking to collect. It's not mine. I didn't have this card. I didn't.
You've never made a payment on this. You've never made a payment on this
payments
card.
on these charges. No, I did not.
Okay. Thank you. Response, Ms. Codrington.
Statements were sent to the defendant's current address. Payments were made timely at the time that payments were being made. The credit card statements, this is an old credit card. So cards do change and card numbers do change because people lose credit cards and people change credit cards. And as it has with every other credit card company, your card number will change when you lose credit cards. Things like that happen. Most people do not maintain the same credit card number. However, what is maintained on these documents is that he did use the card. All these documents were sent to the same address where he resides today. Plaintiff has never received an objection or any letter from the defendant stating that this is a scam or he had never taken out this card. However, these statements were being sent to his home for years and we've never received any objection to them.
All right, and we first met on June 8th of 2026 and May of 2026. Have you heard from the defendant concerning this matter on June or May?
1 second.
I think we have a hearing date of June 8th, approximately, I would say. And then May 11th, that's today. June 8th is today. May 11th, I'd say that was at probably 3 o'clock.
There was no outside communication outside of the hearings.
All right, I'm going to grant the motion for summary disposition. Not taking into account all the legalese concerning the responding, which it is an admission not to respond in the same format. But otherwise than that, I believe you've proven your theory of motion for summary disposition by preponderance of the evidence, and I will sign the order to follow.
Thank you, Your Honor.
Anything else for the record in docket 2506853, Ms. Codrington?
Nothing further.
All right, I'll await the order to follow. You should be all set. Mr. Gordon, do you have any questions?
I mean, I object to your decision, Your Honor.
All right, thank you. The civil department is one floor down. You can go appeal it, okay? All right, thank you. You're all set. Thank you for your appearance today. I'll sign the order. All right, Ms. Haddad, you're here for Mr. Bouchard.
I am, Your Honor.
All right. And I do not see a Margaret Murray. All right, so we're on the record in 26028845. That is Abigail Senior Apartment versus Margaret Murray. Appearances for the record, Ms. Haddad.
Good afternoon, Rania Haddad, P8497 for the plaintiff.
This is the time set for a motion to set aside the judgment. I'm assuming it was filed by Ms. Murray. And I did have the opportunity to see Ms. Murray's motion. This is set for 2:30. It is now 3:10. I do not see Margaret Murray in the Zoom courtroom or physical courtroom. And last I heard, nobody was by that name in the hallway, but we'll check the hallway just to see. But it would appear that Margaret Murray has failed to appear for her own motion. I'll wait to hear just to see if she's in the hallway. Anything?
Always clear.
All right. All right. So it appears that Ms. Murray has failed to appear. It was scheduled for 2:30. It's now 3:11. Ms. Haddad, how did you want to proceed?
Your Honor, I would ask the court deny defendant's motion. However, I do want to also indicate to the court that upon doing some my due diligence and researching the facts on this case, we will be submitting a voluntary dismissal, and in the orders, the further orders below indicate that the default judgment is set aside. It's come to my attention that this case was filed against the wrong individual. And so just in the interest of judicial economy, so that we don't come back here on another motion to set aside, I'm going to voluntarily set it aside and dismiss it, and I'll submit an order to that effect.
All right. So I'm going to indicate that the defendant, Margaret Murray, and there may be something like she heard from the property manager, or but that the court denies the defendant's motion for fail to appear purposes, but then the plaintiff is going to file a voluntary dismissal on the case.
Correct, and withdrawal of the default judgment in that dismissal.
All right. All right, so Ms. Haddad, I'll wait for the order to follow concerning this file and what we've spoken and put on the record. Anything else on the record in 26028845, Ms. Haddad?
Nothing further, Your Honor. Thank you.
All right, you should be all set, ma'am. Thank you for your appearance today.
Thank you.
Let's see. So we're on the record in docket 20, I'm sorry. 96-029-2694, 96-02694. That of Lafque versus Russell Steele. Appearances for the record, Mr. Smith.
For plaintiff Lafque, Tim Smith, P48259.
Right. This is the time set for have a hearing in the matter. Mr. Steele does not appear to be in the Zoom courtroom or physical courtroom. There was nobody in the hallway. Let me see. And I have this I don't have any notes on this. Mr. Smith, how are we proceeding today?
We were last here on May 11th, Your Honor. That was a hearing after a bench warrant. He had failed to appear for a creditor exam and subsequent show cause a number of years ago. As you can tell from the case number, we've been chasing this gentleman for a bit. We conducted the Q&A part of the examination on May 11th. There were a number of documents responsive to the court's original subpoena that he was served with. So the court set today as a control date to ensure two things. One, I got the documents, in particular bank records. And secondly, that all questions that may arise out of those documents were to be answered. The court did send out a notice to appear to both myself and the defendant. He's failed to appear today, which is not surprising considering his history here. We would ask the court to do a show cause or allow us to file a show cause. We'd like to serve it via 9-day mailing to his address of record, which I believe is current because he gave it when he got brought in on the bench warrant a few months back.
All right. All right. Yeah, I think this one, I think this file is in between the paper file and the electric file, because I think my notes are in the paper file on this, because we now, as you've cleared up why we set this, it makes normal sense. This is kind of a normal case. So we will grant the show cause for the fail to appear, and we'll motion this for show cause. And then you can submit it under the 90-day order. We'll set the hearing for show cause. And then the only thing I'd ask is that you have, if Mr. Steele doesn't appear for the show cause, have the full number available so we can set bond on his show fail to appear for show cause, which would be, I would think, like 30 days in the future.
You bet. And we'll prepare that. We'll get a date and submit that to the court, Your Honor. And we'll, just so that we're clear, we'll effectuate service on the show cause order via mail 9 daes ahead of the hearing date. Correct?
Perfect.
Okay.
Perfect. Yes.
We'll take care of it.
All right. All right. Anything else for the record in 9602694, Mr. Smith?
Nothing, Your Honor. Have a great rest of your day. We'll see you.
You too. Take care.